Oregon's new gun laws that could put you in jail today. Imagine being arrested not for new violence, but for something you already own. In Oregon, that scenario just went from what if to reality. On September 26, 2025, Senate Bill 243 took effect. It didn't just tweak gun laws, it criminalized the ownership of devices that accelerate fire. It shifted how concealed carry works, and it set a new requirement, a license just to buy a firearm. Coming March 15, 2026. If you live in Oregon, what you thought was legal yesterday could land you in jail today. In this video, we'll break it all down, what SB 243 actually does, and what it bans, what counts as a rapid-fire activator under this law, the difference between misdemeanor versus felony penalties, how this change concealed carry rules and buy permit requirements, what gun owners must do now to protect their rights. Welcome to Firearms Law Advisor. Not politics, not spin, just the raw truth about legal battles shaping your future. Stay ahead of the fight. Like this video and subscribe now. Chapter 1. SB 243, the new law that changed everything. This isn't just another gun bill. Senate Bill 243 is a full-on restructuring of how Oregon treats your rights under the Second Amendment. When it quietly took effect on September 26, 2025, most headlines ignored it, but behind the legal language lies a bombshell. It's now a crime to merely possess certain firearm accessories you may already own. Key takeaways: SB 243 bans rapid-fire devices, not just sales or transport, but personal ownership too. It aligns Oregon with Measure 114, but moves key parts forward on its own timeline. Lawmakers baked in vague terms that give law enforcement broad interpretation powers. This bill is dangerous, not just for what it says, but for how quietly it went into effect. Thousands of Oregon gun owners could be breaking the law without knowing it, and the worst part, ignorance of the law won't protect you from felony charges. Chapter 2. What is a rapid-fire activator, and why it's a trap? You've probably heard about bans on bump stocks or binary triggers before, but Oregon's new language creates a catch-all category called rapid-fire activators, and this legal term is way broader than you think. What's banned under SB 243? Bump stocks, binary trigger systems, burst trigger systems, forced reset triggers, FRTs, hellfire triggers, trigger cranks, and rapid-fire switches. The bill defines these as anything that increases the rate of fire of a semi-automatic firearm. But here's the issue. There's no clear standard for what rapid means. That vagueness gives police and prosecutors room to interpret common modifications as crimes. And guess what? You don't even have to use them. Simply possessing one of these is now enough to be arrested. That means if you bought a binary trigger years ago and forgot about it in your gun safe, you could now be charged. Chapter 3. Felony versus misdemeanor. Know the stakes before you act. SB 243 isn't just regulatory. It criminalizes behavior that was legal for decades, and the difference between a misdemeanor and a felony can be the difference between a slap on the wrist and years behind bars. Legal penalties under SB 243. Class A. Misdemeanor. Possession of a banned rapid-fire activator. Punishable by up to $300, 64 days in jail, and a $6,250 fine. Class B. Felony. Transporting, selling, manufacturing, or offering to sell these devices. Carries up to 10 years in prison and $250,000 in fines. This makes Oregon one of the few states where owning an inanimate piece of metal or plastic without ever using it can be treated almost as harshly as committing a violent crime. Prosecutors don't need to prove malicious intent. If the device is found in your home or vehicle, that alone could lead to charges. Chapter 4. Concealed carry just got complicated. If you have a concealed handgun license, CHL, in Oregon, you've already jumped through hoops. But SB 243 throws new obstacles in your way, especially if you carry in public buildings or city spaces. Major changes to CHL rules. Local governments can now prohibit CHL carry in specific public buildings, even if you're licensed. Affirmative defense rules are being weakened. This means if you're caught with a firearm in a prohibited zone, you may no longer be automatically protected just because you have a permit. Expect more gun-free zones and restrictions imposed at the local level, city by city. This is a strategy seen in other anti-gun states. Death by 1,000 cuts. You still have the right to carry, but fewer and fewer places where that right actually means anything. Chapter 5. The timeline that could catch you off guard. Many gun owners assume they'll have months to adapt to a new law, but SB 243 is already in effect, and more changes are coming in just months. What's happening and when? September 26, 2025. SB 243 became enforceable law. Device possession is now criminal. Concealed carry rules updated. March 15, 2026. Permit to purchase system launches based on ballot measure 114. Anyone buying a gun will need to apply for a license before purchase. Gun stores may need to verify permit status before any sale. This gives the state several months to build an infrastructure of delays, forms, and restrictions. Meanwhile, Oregon gun owners will have to scramble to stay compliant. If the permit system fails, it could turn into a de facto ban, because without a license you can't buy, and the state doesn't need to outlaw firearms when they can simply refuse to process permits.